My name is Steve Appel from Work Comp Matters, and tonight's show is on the continuing case against Dr. Bruce Fishman. Now, in preparation for this show, I've been told by a lot of people what guests to have on the show and what guests not to have on the show. I've also been told by a lot of people what to say and what not to say on the show. I've also been told by a lot of people to not even air the show because I could be sued. Well, I gave it a lot of thought and could only come to one conclusion. Fuck it. Now here's the show.
They used to say if a man could fly, he'd have wings. But he did fly. He discovered he had to. Do you wish that the first Apollo mission hadn't reached the moon, or that we hadn't gone on to Mars and then to the nearest star? That's like saying you wish that you still operated with scalpels and sewed your patients up with catgut, like your great-great-great-great-grandfather used to. I'm in command. I could order this. But I'm not. Because Dr. McCoy is right in pointing out the enormous danger potential in any contact with life and intelligence as fantastically advanced as this. But I must point out that the possibilities, the potential for knowledge and advancement is equally great. Risk is our business. That's what this starship is all about. That's why we're aboard her. You may dissent without prejudice. Do I hear a negative vote?
Stand by SOT-1.
Standing.
10 seconds. Ready, rollin'. Ready, SOT-1.
Ready.
In 4, 3, 2, 1. Roll in.
From the Roundtable at legendary Uncle Studios, welcome to another edition of Work Comp Matters, the central location for you employees, you employers, and you independent contractors. My name is Steve Appel, and I'll be your host for the next hour with some talk, some news, and hopefully some answers about Work Comp Matters. Thanks for being part of the show, and if you can break away from your Work Comp Matters, feel free to give us a call and clue us in with your questions, comments, and or concerns. The phone number worldwide, 818-357-4120. You can send me an email to wcexaminer@aol.com. You can be old school and send me a fax, 818-475-1437. With me in studio, the Chief of Staff, my right-hand man, Dr. Michael Zyma, the best-dressed man in workers' compensation, Mr. Ted Durden, my protege, Attorney Robert Ozeron. Scott Walton of Uncle Studio is engineering on the board. Back in Munich, Germany, John Scalia, back at Work Comp Central, making sure the whole damn thing goes right, is Ms. Kristen Chavez. Well, good evening, everybody, and welcome to another edition of Work Comp Matters. We're brought to you by WorkCompCentral.com. If you want the number one location for workers' compensation in California or around the United States, blogging, education, credits, the whole ball of wax regarding workers' compensation, check out WorkCompCentral.com. They've got a free, no obligation, 7-day full-fledged membership. Check them out at WorkCompCentral.com. We're also brought to you by A1 Law. If you want the number one computer management system used by more California workers' compensation attorneys than any other system in the damn Kuiper Belt, give me a call, 818-357-4120 for your no-strings-attached money-back guarantee, $1 a day, A1 Law. And last but not least, we're brought to you by Santa Monica Tickets. If you want front row, sold out, heck, hard to get, it doesn't matter. Give Brian a call at 310-395-8587. Tell him you were referred by Work Comp Matters and or Steve Appel. He'll give you a 10% discount on your tickets. Well, folks, I got to tell you, the blood is boiling, the juices are flowing. We're talking tonight about the continuing case against Dr. Bruce Fishman. And it was about 3 weeks ago that Ted brought this story. Fishman. Did I say Schiffman again?
Yeah,
I
right.
always screw it up, and I don't know why. Probably because I'm not that familiar with Dr. Bruce Fishman. Ted brought this story to me about 3 weeks ago, and we went through several revisions. And then this past Monday, I essentially sent this story called The Continuing Case Against Dr. Bruce Fishman by Steve Appel and Ted Durden to WorkComp Central. My understanding is by the time you hear this broadcast, this story will be on WorkComp Central. Today at 2 p.m., Judge Boylinda Schultz once again presided over the hearing, the administrative hearing of Dr. Bruce Fishman to determine if his panel qualified medical examiner's license should be revoked and if he should be suspended from participating in the workers' compensation system. Here are the relevant facts of the case. On August 9th, 1983, Dr. Fishman was convicted in Michigan of conspiring with Ronald Benyard and Edwin Wolf of prescribing medications for Schedule II controlled substances outside the usual course of medical practice and for no legitimate medical purpose. Dr. Fishman served approximately 3.5 years in federal prison and was given a 100% full clearance by the medical board to practice medicine in 1990. In 2003, Dr. Fishman successfully applied for and received his California panel qualified medical examiner's license. Dr. Fishman again successfully applied for and renewed his license in 2005, 2007, 2009, 2011, 2013, and 2015. On April 26th, 2017 and November 20th, 2017, 2 letters were sent to the DWC by either Patrick Nazemi and or attorney Ronald Tim, a former business partner of Dr. Fishman, regarding the felony conviction. Nazemi is the former partner. Tim is Nazemi's attorney. On April 19, 2018, the DWC issued a notice of suspension, which Dr. Fishman appealed. This matter was then set for continuing hearings May 29, 2018, August 7, 2018, August 31, 2018, December 19, 2018, and again today. The question is, why is this matter taking so long? Why all the continuances? As part of fraud fighting, the state legislature recently enacted Labor Code Section 139.21, which mandates the administrative director shall promptly suspend, pursuant to Subdivision B, any physician, practitioner, or provider from participating in the workers' compensation system as a physician, practitioner, or provider if the individual or entity meets the following criteria in the statute. Supporters of Dr. Fishman claim he has paid his dues to society. He has led an exemplary career in California workers' compensation, and the applicable statutes involving revocation of his PQME license are unconstitutional. Opponents of Dr. Fishman allege the evidence is clear and irrefutable. Dr. Fishman was convicted of a felony in 1983, and he failed to disclose this felony every time he signed under penalty of perjury that he had never been convicted of a felony. At today's hearing, and I will give you the disposition, I have it right here. At today's hearing, the judge again continued the case for one final round of briefings and apparently will issue a decision and or recommendation on suspension on or before March 11th. And there, folks, is the current status of the case with Dr. Bruce Fishman. Now, in preparation for airing this broadcast, I went ahead and contacted Dr. Fishman's attorneys, Mona Nemat, who I've known for many years and I respect very much, as well as Howard Kapp. I had never heard of or met Howard Kapp within the past 2 weeks. I also contacted Ronald Tim, who I had never met within the past TYM, who I had never met within the prior to the past couple of weeks. You'll have to excuse me. I'm a little bit nervous about doing this show, and I will explain why now. I received, in response to those inquiries about offering them to be on the show, a 5-page email from Attorney Kapp, as well as a responsive 2-page email from Attorney Tim. Because of the contents in those emails, I have decided not to have any guests on the show, but simply read both emails. So without further ado, we're going to start the show off by reading the email from Attorney Kapp. And this email, which, by the way, both emails are posted on my Work Comp Matters channel. You can check them out. You can print them out. You can digest them. As Mike would say, you can make a love to them. But here we go. And this was sent to me January 28th, 2:29 p.m. Dear Mr. Appel, we had the opportunity to speak last week when you called me initially claiming that you are interested in the multiple continuances of the workers' compensation issue involving Bruce Fishman, MD. I was very curious how you discovered this seemingly obscure matter and how you seem to be focused on the least controversial or newsworthy item possible. This later became clear to me when you informed me that you thought that Labor Code 139.21 was over-inclusive and otherwise bad policy. If so, I don't know why you didn't focus on the obvious newsworthiness of the problem with using an over-inclusive statute to restrict the practice of a physician who was convicted of a crime nearly 4 decades before. That, plus the fact that Dr. Fishman has performed in the workers' compensation system for nearly 3 decades without a single complaint of note, would seem to be on its face much more newsworthy because it centers around a statute which, read expansively, does not serve the public interest. No one questions that the legislature and governor have the right to protect the public from people who have been convicted of crimes that are both relevant and relatively recent. But this seems to be a perfect example of the type of intractable hounding of people because of ancient misbehavior, such as that in Les Miserables or The Scarlet Letter. And Mike, you're going to start up again with Indeed, but I want to respond to a couple of things. Firstly, although I may have read a couple of Dr. Fishman's reports over a couple of decades, I've never spoken to the man. And in my opinion, I believe it's extremely newsworthy of the multiple continuances in this case. And I raise the question, why? If anybody out there has, and by the way, we've got 101 shows in the tank. That's 101 hours of work comp matter of me and the fantastic crew that I have assembled here. And if anybody has listened to my shows, I have always rallied against unnecessary continuances for one reason or another. Now, I'm not saying the continuances in this case are unnecessary, but we've got 5, if not 6 continuances for something that's supposed to be given notice and had a hearing within 10 days, okay? We're now going on 6 hearings, 5 continuances. So with all due respect, Attorney Cap, I think the continuances are extremely newsworthy. The fact that whether or not Dr. Fishman should have his license revoked and the privilege to practice in the workers' compensation system, I don't take an opinion on that. That's not where I don't want to go down that road, because as the rest of the email will explain, I got to tell you, when I first received your email, Attorney Cap, I felt scared. Okay? I own a 3-bedroom, 2-bathroom house in Woodland Hills. Fortunately, I am not living on a month-to-month. I've got a little bit of savings in the bank, okay? Unlike Robert, I don't own stocks. I don't own bonds. I'm putting my son through law school, and I'm helping my daughter out. And so I'm living on what I consider to be very conservative means. And if you've listened to the show, if you've listened to over 100 hours of tape, you will find that I do my best not to give my opinion. I do my best to bring on guests and assemble a crew that will give both sides of the argument, and then I can moderate. There are very few topics that I actually take a hardline opinion on them. One of them, of course, is shutting down the government, which I've said forever. The government should not be shut down for any reason, and any time it is, we should not be paying our U.S. senators and our U.S. representatives a salary. The other thing I've taken a very hardline stance on is multiple continuances. Now, my understanding is that no one has objected to these continuances, either party or the judge. But I don't know. Okay, everybody agreed to the continuances. So you know me, guys, I like to use an extreme to prove my... Well, what if everybody agreed to 100 continuances in the case? Does that make it right? I don't think so. And so the question that I ask, and the reason why this story in my mind is newsworthy, is because of all of the continuances. Why? Okay, I'm going to turn the rest of the email over to my chief of staff. He's the doctor, Mike Zyma. Or the next paragraph or two. Go ahead.
Sure. Okay, picking up where Steve left off. Okay. Indeed, the Supreme Court of California has noted that in the past. Whatever, I don't know what it was. But since you are not an attorney and I am preparing for the hearing this week, which you know, I'm not going to spend my time preparing a legal brief for you. During our initial conversation, I asked if you knew Patrick Nazemi or of any of the other related litigation. You did not ask me who he was or how to spell his name or about the other related litigation. My assumption that the time was that the reason you did not ask was that you already knew of that individual and his ongoing extortion and obsession with Dr. Fishman.
All right, let's stop right there. Now, before Ted brought this story to me, I had never heard of Patrick Nazemi. I had heard of the company, Mike. He's the CEO, the CFO, the president of Med Legal Associates.
Main shareholder and officer.
Yeah, I've heard of that, but I've never heard of Patrick Nazemi. I've never done business with Patrick Nazemi. Now, on the other hand, Ted has known and Ted does business with Patrick Nazemi for years. And when Ted first brought me this story, he disclosed that he's known Patrick Nazemi for years. He's done business with Patrick Nazemi for years. And the one thing I said to Ted is that no matter where this story leads us, we're going to tell the brutal truth, no matter where it leads us. Is that correct, Ted?
Absolutely.
Mike, please continue.
Okay. Nonetheless, I was willing to talk to you and give you the benefit of the doubt. I was willing to provide you with some background information. By the end of our conversation, which eventually included Mona Nemat, who you...
that's Mona Nemat.
Sorry.
Please continue.
Mona Nemat. Sorry, Mona. Who you know, you agreed that it would be wise to postpone any public disclosure or discussion until sometime after the upcoming hearing.
Actually, I said I wanted to postpone it at least 1 week and possibly after the hearing. I never said I would postpone it till after the hearing. Please continue.
And you had had some additional time to look into the larger policy issues of hounding physicians for ancient items. You also indicated that you needed to check your sources and your facts after you were set straight on a couple of matters. You indicated that there was no need to rush. I am informed that you contacted Mona this morning and had advised her that you intended to go forward with the webcast on Wednesday night and that you were now including Patrick Nazemi and or his attorney Ronald Tim, whose sole source of income appears to be this obsession with Dr. Fishman.
Okay, now firstly, I spoke to Nazemi for 2 minutes, and he said he was going to call me back the next day, and rather than getting the call, I've got the call from his attorney, Ronald Tim. And yes, my initial desire was to have Tim on the show by telephone. Of course, I also extended an invitation for the
Mr. Cap.
Mr. Cap to come on the show. Mr. Cap declined. Mr. Tim was more than happy, and I was planning on having him on the show until I received this email. I thought long and hard, spoke to a lot of people, and I changed my mind. I decided not to have Mr. Tim, Attorney Tim, on this show. Please continue.
It is curious how you are now acknowledging knowledge of these people that only a few days ago you claimed not to know.
So, what does that mean? Do you think I'm lying? I got news for you. Never in my professional career, 28 years in workers' compensation, or on this podcast, have I ever lied. Now, I'm not saying you're accusing me of lying. I'm just saying that that sentence in and of itself makes me think that you think I'm lying. I have never lied on this show, and I have never lied in my professional career. Is that, or we still got a little more? Or?
Well, why don't we do a few more paragraphs?
I know we have the R for Robert, which starts, I am informed. Are we there yet or no?
Yes.
Yeah, we are.
Okay, Robert. Oh, I'm sorry.
I think we should go Ted next, right?
We skipped Ted. Okay, Ted, go ahead. Pick it up, Ted.
Okay. You did inform Mona that Nazemi/Tim had initiated the contact and controversy with the DIR by way of 2 letters. I have no doubt that they did this, but I'm curious how you have this information.
I got it from Ted. Please continue.
It is not readily available, but can be ascertained through a public records request. My question is, what does it matter how you got the information? If it's true, if it's factual, then it is.
Well, no. I've got nothing to hide. There ain't nothing up my sleeve. I'm answering these questions.
Right.
Please continue.
Given how you told me that you hardly knew about Mr. Nazemi and his attorney during our conversation last week, I can only surmise that perhaps your relationship with Nazemi/Tim goes back further than you previously indicated. Again, speaking of something which he does not know.
Mr. Attorney Cap, it doesn't go back. Well, I don't have a relationship with him. In the past 3 weeks, I've spoken to him once for 2 minutes. And before that, in my 28 years, I've never spoken with him. Never. Robert, why don't you pick it up where it says, well, I recognize.
Okay, boss, and I just want to say thank you for letting me read your email here.
You're welcome.
Okay, where would you like me to pick up from here?
I recognize that your webcast. Follow, my boy, follow.
Second page.
Yes. I see that you put notes, but this is the letter S there. You put
that's right.
Okay. While I recognize that your webcast has a seemingly microscopic footprint. Wow. Okay. He's real. Okay.
Okay.
Oh, he's bringing it. I see.
No.
This is a fastball, I think.
Hold on.
Why does he got to demean you like that?
Well, you know what? I think my it's actually a radio podcast. It does have a microscopic footprint. I mean, he's not like Donald Trump talking about my hands, right? Okay. My podcast does have a microscopic footprint. Boy, that must have been a really bad joke. Please continue.
No, well, more than his podcast. Microscopic footprint. It seemed to have 100 listeners per episode. It seems that you are trying to create contact for Nazimi Tim to continue to press the one-man Nazimi-funded vendetta against Dr. Fishman based on an ancient felony.
Now, that is totally untrue. I'm going to tell you exactly what I'm trying to do. I'm trying to obtain content that is relevant to California workers' compensation, employment, and labor law to promote me and my podcast. I have no desire whatsoever to promote Mr. Nazimi or Mr. Tim, unless, of course, they want to advertise on the show. Then I'm more than happy to promote them no matter what. I mean, come on, write me the check. But so far, nope, haven't received a dime. Go ahead.
Okay, I should also note that the subject line that no one mentioned is titled defamation. So when he sent you this email. Okay. As far as I can tell... We've mentioned
it, believe me.
Well, that's the subject line of the email there. As far as I can tell, there's probably some payment and or arrangement between you and Nazimi group that has caused you to act as their de facto agent and under the guise of quote-unquote journalism to continue to spread falsehoods and irrelevant facts about Dr. Fishman.
Let me
deboss you of any assertion that Nazimi is nothing more than a bully and extortionist because Dr. Fishman refused to knuckle under his outrageous behavior. End paragraph.
All right, let me say something for the record right now. I have not received a single dime from Attorney Tim or Mr. Nazimi. But if they want to advertise on the show, I am more than willing to take their money. I'm more than willing to cash their check as long as whatever they want to talk about on the show does not defame or libel anybody. But as of right now, this recording, they haven't paid me a single friggin' dollar.
I have a feeling neither one of these people are going to want to advertise with you, but okay. Should I continue?
Oh, please do.
Let me provide you with a little bit of background. For many years, Dr. Fishman, having obtained appropriate board certification after his one-time 38-year-old felony, was evaluated, as required by law, by the Medical Board of California in 1990 and allowed to return to practice in medicine. The MBC was fully aware of his 1982 felony, but recognized in 1990, found him to be fully rehabilitated and no longer a danger to the public. And no one has ever asserted that their confidence was misplaced or violated. At that time, his license was returned to Dr. Fishman with some restrictions. Should I continue reading?
No, I think let's go ahead to Mike. Go ahead and take up, I think, all of these residual restrictions.
All of these residual restrictions were removed in 1994 by the Medical Board, which was frankly very complimentary. In the decades since, Dr. Fishman has acquired quite a positive reputation and practice since then. He completed his training in occupational medicine and obtained full board certification in that recognized medical specialty. He has engaged in active practice, including surgeries, in all of those intervening years, and without further ado, Dr. Fishman is the textbook example of a rehabilitated person as objectively determined by the authorities and not by his vengeance-motivated obsessive pursuer, Patrick Nazimi, his self-appointed inspected Javert, except with the smokescreen of a legal justification. May I go on?
Yeah, go ahead.
In approximately 2012, Patrick Nazimi, an unlicensed self-proclaimed medical practice administrator convinced Dr. Fishman to allow him to manage a portion of Dr. Fishman's workers' comp practice. The term of the contract was initially 1 year, allowing either individual to terminate the contract according to its terms thereafter. Nazimi made a gigantic amount of money from his relationship with the already well-known and well-regarded Fishman. For Nazimi, a giant cash cow. After approximately 11 months, including months of increasing dissatisfaction with Mr. Nazimi's services, Dr. Fishman terminated Mr. Nazimi's services. Mr. Nazimi was clearly unhappy with that, and several months later, as the residual receivables dissipated, Mr. Nazimi lured Dr. Fishman over to his office on the pretense of discussing some logistical issues. At that meeting, Mr. Nazimi demanded that Dr. Fishman pay him $500,000 or he would publicize Dr. Fishman's then 32-year-old felony and ensure that it had the widest popular distribution in the workers' compensation community.
Okay, let's stop right there.
So not your podcast.
My name is Steve Appel. You're listening to Work Comp Matters. We're talking about the case of Dr. Bruce Fishman. We are currently reading an email. From Dr. Bruce Fishman's attorney, Howard Kapp. I do not know if the contents, some, a little, most, or all, are true. They are what was written to me in an email by attorney Howard Kapp, and we are reading it word for word. The reason why I'm reading it word for word is because when I first got it, I was scared. After thinking about it and talking to some people, I decided the best way to not be scared, and folks, believe me, as I record this now, I am not scared. We're reading it word for word. Let's go ahead and continue with the rest of the page. Ted, why don't you pick up where Mike left off?
Since that was prior to the 2015 adoption of Labor Code 139.21, the sole purpose of this extortion was to inflict the maximum amount of emotional distress upon Dr. Fishman. This is not my opinion, but the now court-confirmed finding of a jointly selected arbitrator. Interestingly, that arbitrator would later describe this as certainly an ambush of epic proportions here. Dr. Fishman is lured to a meeting to discuss outstanding accounting issues only to be confronted with a baseless demand for payment and a threat of exposure. The arbitrator would later find that the actions taken by Mr. Nazimi was extreme and outrageous, and not only had the probability of causing Dr. Fishman emotional distress, but actually did.
You know, what I find interesting about this email, and believe me, being in workers' comp, I think you'll all agree, the only one that can diagnose emotional stress is a doctor. Doesn't say in the email that the good Dr. Fishman was evaluated by a psychiatrist or a psychologist.
That's not necessarily true, boss.
Oh, really?
Yeah,
okay.
Correct. Pain and suffering is a general damage.
I didn't say pain and suffering. I said emotional distress.
That is emotional distress is pain and suffering. It's general damages, not special damages.
I didn't know that they were always the same thing. I thought sometimes they would be mutually exclusive.
Sometimes they are.
Okay.
So you're not incorrect. But general damages are those which you don't generally quantify. Okay. Special damages are specific medical bills. So if you're being harassed and you're having sleepless nights, you may not have a specific medical bill, but if you testify to that and a jury, for example, wants to award you damages for it, they can.
So you don't need a doctor to testify or write a report as to you suffering emotional distress. You can simply testify that you suffered it without a doctor's opinion?
Yes. If you suffer extreme emotional distress, you're going to want to see some medical records perhaps to substantiate it. But
I would think so.
Well, no, plenty of people have emotional distress over potentially being extorted, for example, and this is just potential. I don't know the specifics if this is true or not.
Sure.
But that seems like something that would cause emotional distress, but not necessarily something that would drive you to the doctor in the morning. Most people don't go to the doctor, right? Anyways, that's the general versus special damages.
Of course.
Usually you do like to base your general damages on your special damages. You like to see the medical bills that say they have depression and anxiety.
Shine the medical bills. What about just substantial medical evidence of a report? Shine the bills.
Well, general pain and suffering, or mental anguish, or even inconvenience. These are all general damages that a judge can just find, or an arbitrator can just find, or a jury, that is, a fact finder. There's no need for specific medical bills.
We are halfway through the email sent to me by attorney Howard Kapp. We've got John Scalia coming up next. We're then going to finish with the email of Howard Kapp and then go on to the email in response to it by Ronald Tim. But he's been a regular contributor to the show, and without further ado, here is, from Munich, Germany, here's retired attorney John Scalia.
Hi, this is John with the Work Comp International Report from Munich. Well, this week, I'm going to sound more conservative than Robert. Don't believe me? Well, listen to the podcast, and when I finish, you let me know what you decide. I'm going to talk about two things. First, I have a regular feature, which I'm now going to call Trump Takes. Well, Donald Trump decided that it was embarrassing for the most powerful country on earth not to have a fully functioning government. So he temporarily gave up on his claim for $5.7 billion to build the Trump Towers along the border. However, when he did so, he kept the nuclear option on the table. The nuclear option, of course, is his declaring a national emergency and simply taking the $5.7 billion in order to build his wall. Now, my understanding is that the Republican Party has always maintained it is the party of less government, and it is the party against executive overreach. So what's going to happen is if Trump does do that, you know that all the liberal organizations are going to take him to court and argue that it's in excess of his powers. My question is, what will the Republicans do? The party of less government, the party that's always saying the federal government does too much and abuses people's rights. Be interesting to see if they put their money where their mouth is. Okay, the second thing I'm going to talk about is actually employment law. Believe it or not, yes, employment law. Recently, there was an unfortunate incident where a flight attendant died of a heart attack on a flight from Hawaii to New York City. It was an American carrier, I can't remember which, but one of the big ones. And the flight attendant, according to the article, had worked for 30 years as a flight attendant. So we know it was not a young man who died. Now, there are laws in America, and for good reason, against discrimination in employment. One is against age discrimination, another is against discrimination because of physical disability. The Age Discrimination Act prohibits discrimination for people who are between 40 and 60 years old. You should not automatically assume somebody cannot do the job simply because of their age. I find that to be reasonable. America's Disabilities Act says, well, you shouldn't assume that because somebody's missing a leg, they can't work as an attorney. Also reasonable. But like most litigation that gets passed and eventually into the hands of us lawyers, reason sometimes takes a back seat. So now in America, I don't think there's a single employer who even would think about asking a potential employee, well, how healthy are you? That would be grounds for a lawsuit if that person didn't get hired. Nor can they ask, okay, you've been working in employer XYZ for 4 years. How many sick days have you taken? They would probably get sued again. Now, my point is, if you're an employer, and I have been an employer, I've hired people in addition to being an employee, aren't you entitled to find out whether that person's going to show up for work? I mean, it seems to me that you should be. I mean, if you say, well, you worked for 4 years, how many sick days did you take? Is that an unreasonable question? Does that mean you're discriminating because of the person's health? Or maybe you're discriminating because they're not working? I mean, it seems to me an essential part of doing a job is being there and showing up for work. So I think employers should be allowed to do that. Personally, when I was over 50 and interviewing for jobs, I would look at the interviewer and I would say, look, I know it's against the law for you to ask me about my health or any of my activities. So I'll tell you what, I'm going to take the burden away from you. I'm going to tell you what I do. I run marathons. I play tennis. I run and I do all kinds of exercise. I downhill ski. And so I would say, there, now you have it. Oh, and by the way, when I ended my legal career in California, having worked for about 45 years, I believe I missed all of about 4 or 5 court appearances due to illness. Now, I'm lucky. I mean, obviously, that would be an unreasonable standard to apply generally, but my point is simple. My point is part of doing a job is being there to do the job. So I think a law that says you can't ask about that is unreasonable. Well, that's my conservative podcast. Enjoy it while it lasts. May never get another one. And I let you decide how conservative I was. That's the view from Munich this week.
And John, thank you very much. It's time for the Work Comp Central news. If any of you get a chance on WorkCompCentral.com, check out the January 30th report entitled Marketeer Pleads to Kickback Charge of $211 million in compound drug scheme by Greg Jones. Federal prosecutors in Southern California secured another conviction in the case involving more than $211 million in payments for compound drugs the doctor is allegedly prescribed in exchange for kickbacks. I'm going to pronounce this wrong. Jean Picard pleaded guilty to 1 count of paying kickbacks for people who arrange compound drug prescriptions that were filled at pharmacies owned by Hudson Malamed. I know I screwed up the words wrong, but if you get a chance, check out WorkComp Central Wednesday, January 30th by Greg Jones. Marketeer pleads to kickback charge in $211 million compound drug scheme by Greg Jones. My name is Steve Appel. You're listening to WorkComp Matters. We're talking about the case against Dr. Bruce Schiffman. We're halfway through the email that was sent to me by attorney Howard Kapp. And I think I've got Mike down on, page 3, starting several months after Fishman?
Yes.
Go ahead.
Several months after, Dr. Fishman refused to pay Nazemi's $500,000 blackmail. Mr. Nazemi, through other attorneys, initiated a totally meritless binding arbitration, originally claiming $2.4 million in damages. Nazemi's shell company claimed throughout this litigation that he was entitled, having stopped all work on the agreed end date, to damages of $90,000 a month, over $1 million per year, for the remainder of Dr. Fishman's career because supposedly Dr. Fishman's notice of termination was done, quote, wrong, end quote. Nazemi and his attorneys pursued this legally ludicrous claim until the very end.
And again, we're reading the email that was sent to me by attorney Howard Kapp. Mr. Kapp was invited to be on the show. He declined, but he sent me this 5-page email. Obviously, I do not verify it being correct or not. This is just us reading his email word for word. Ted, you've got the next paragraph starting after several years.
After several years of highly contentious litigation, the arbitrator found that all of the claims made by Mr. Nazemi and his attorneys were meritless and awarded Dr. Fishman $113,400 in damages, along with another $418,257 in attorney's fees and $96,849.31 in legal costs. This was nasty, brutal litigation involving a host of claims asserted by Nazemi and his earlier lawyers. All of them were spurious.
Robert, start off eventually.
Eventually, the arbitrator conducted a formal 5-day trial and, after allowing months and hundreds of pages in post-trial briefs, found that every claim by Nazemi was factually meritless and legally wrong. The arbitrator found, for example, that all of the innumerable claims that Dr. Fishman had dishonored the contract by taking more than his contractual share of residuals was meritless. He found that that Fishman was the victim of Nazemi's breach of contract, and that, as above, that Nazemi was an unabashed extortionist. In fact, Nazemi himself had largely proudly admitted to his extortionist behavior in his deposition, apparently uninformed that blackmail is both a crime and tortious. Nazemi promptly challenged the lawfulness of the arbitration that he initiated in the Superior Court. As usual, he lost on every ground. He has filed an appeal but did not post an appellate bond, so we are attempting to collect on the judgment, which is now approaching $1 million, as he seems to be shifting money amongst his corporate shells to evade collection. Since all litigants have a right to appeal from the Superior Court, that appeal has been largely processed, and we are awaiting an oral argument in the Court of Appeal next month. If we are fully expected to prevail there too, like we have prevailed everywhere else, Nazemi, who has a lucrative business, has not won on the merits of any of the innumerable claims he has pursued against Dr. Fishman.
My name is Steve Appel. You're listening to WorkCom Matters. We're talking about the email that was sent to me by attorney Howard Kapp. We do not take a position whether or not any of it, some of it, most of it, none of it is true or not. We're reading it word for word. Mr. Nazemi also filed another lawsuit using Mr. Tim in the Superior Court days before he knew that the arbitration award would be finalized. He is seeking the identical damages that he had claimed and lost in the arbitration matter. After he compelled us to spend time preparing a demurrer to that action, he dismissed that action just in time to avoid the filing of our demurrer. You know, before I start having Mike read the next paragraph, we've been reading pages 2 to 3. I'm wondering, what the hell does any of this have to do with whether or not the QME license and the privilege to practice should or should not be suspended in the workers' compensation system? But you know what? We're reading it word for word. Mike, please start off again. He also filed
yet another lawsuit at the same time, claiming to be a whistleblower representing the interest of a slew of public entities, including the state of California and insurance companies. He delayed serving or notifying Dr. Fishman of that lawsuit for about a year. While his lawyer offered the state of California and many other entities the opportunity to join that lawsuit, everyone declined. That is, as the judge would later comment, another Nazemi-Tim lawsuit rehashing and relabeling the same arguments he lost in arbitration. In that lawsuit, his lawyer, Mr. Tim, asserted 2 causes of action. One of those causes of action was dismissed on demurrer permanently by the Superior Court judge as lacking any legal merit, even theoretically. In overruling our demurrer regarding the other cause of action, the Superior Court judge indicated that his decision was only based on technical flaws in our demurrer paperwork, and on the record told Mr. Tim that it was extremely likely that he, the judge, would dispose similarly of the remaining claim once it was properly presented on its total lack of legal merit to him.
You know what? In one respect, I have to agree with attorney Howard Kapp. I am not an attorney, but I do have 28 years in workers' compensation, and I am a college graduate. I don't know what the hell any of this has to do with the current action before the WCAB. But we'll continue reading word for word. Ted, go ahead.
Okay. Well, I think the word that comes to mind is deflection. Where did you leave off at, Mike?
Start out, the judge has
repeated that.
The judge has repeated that on the record several times and noted that this meritless lawsuit was a rehash of the same allegations rejected by the arbitrator on the merits. Ultimately, the judge put a stay on the amendment of that lawsuit pending the outcome of the frivolous appeal from the notification of the arbitration award. We fully expect that once the appeal is resolved after the February hearing, this lawsuit will die as well.
Keep going, Ted.
Because of the pendency of these meritless lawsuits and Nazemi's last-ditch appeal, there is a considerable public record of the above, including that Nazemi is an adjudicated extortionist and that his claims have uniformly been rejected by neutrals.
And you know what? Even if everything that Ted just said is 100% true, what the hell does this have to do with the Workers' Compensation Appeals Board? Robert, please continue.
I should also note that Mr. Nazemi and probably Mr. Tim made a point of distributing photocopies of their meritless lawsuit claiming to represent the state of California and others. Apparently, they have placed these photocopies in envelopes without a return address, addressed to attorneys, insurance companies, and regulators in the workers' compensation universe with a specific intention of confusing them to believe that the state of California is pursuing fraud and or criminal charges against Dr. Fishman, all of which is nonsense. I have no doubt that Mr. Nazemi and or Mr. Tim had something to do with initiating the present workers' compensation action, although it is abundantly clear that they were trying to undermine Dr. Fishman by dredging up this nearly 40-year-old matter. I do note that the workers' compensation authorities, at least until now, have asserted that this statute applies without exception to ex-felons, although I have been informed by their attorneys and judges that there have been no remotely similar cases. I am informed that there was and may be a serious debate within their own ranks of the wisdom and justice of pursuing Dr. Fishman pointlessly. To the contrary, it appears that the relevant adversaries were all previously aware of Dr. Fishman as one of the most highly respected physicians in the workers' compensation system. The issue here appears to be a legal and political issue, particularly since there is no assertion that Dr. Fishman represents a threat to the system. You are now advised that Nazemi Tim have been hounding Dr. Fishman for years based on these ancient allegations that Nazemi has tried to profit through them by direct, unambiguous extortion and by an attempt to seek damages against Dr. Fishman solely based on his ancient felony, which, of course, had nothing to do with Nazemi. If and when you want to have a discussion after timely processing of the workers' compensation matter, including its anticipated involvement in the court system regarding the wisdom of Labor Code 139.21 in disqualifying this unlimited group of physicians and other providers, I, or Mona, will be happy to discuss that with you. We are not going to get involved with you in or around the time of a pending hearing for which we actually have to prepare. If you want to put Mr. Tim on your webcast, we cannot stop you, but we predict that Mr. Nazemi will instruct him to use your broadcast for rebroadcast for his own purposes. That is, to carry out his long-standing vendetta and extortion threat against Dr. Fishman. You will, now that you know the background, have a duty to verify their anticipated falsehoods. If you allow defamations and or invasions of privacy, you will be held to that extent jointly responsible for this anticipated misuse. I suggest that you act wisely and do not participate in this premature public disclosure of information which you have good reason to know is false and, as a matter of ancient history, not newsworthy or relevant. For now, I will consider this anticipated webcast to be evidence of your cooperation with Nazemi Tim's campaign of slander. Of course, my opinion will change if you act appropriately and defer this matter until you have more information and verify the information, much of which is in the public domain.
And that is signed by Howard A. Cap.
He also did
Esquire.
not say anything like sincerely or respectfully. He just ended the email with his name.
How true. Yeah, how true.
He's very charming.
Law.
He also he also is a Les Mis fan because he used a lot of French words there. I don't know.
That's Howard A. Cap, Esquire, Law Offices of Howard A. Cap, 3731 Wilshire Boulevard, Suite 514, Los Angeles, California, 90010. Website, www.kapplaw.com. He also gives a voice telephone, 213-927-8000. And he says, if you want to reply, contact him. So, if any of you like what he had to say in his email to me, if you don't like, give him a call, send him an email. I
have a comment here.
Sure, just a second. And, if you want to comment to me, 818-357-4120, WCExaminer at AOL.com, contact WorkCompCentral.com. You like the broadcast, you didn't like the broadcast. And by the way, we've got the responding email from Mr. Tim, Ronald Tim, and I want to remind everybody that the email from Attorney Cap is about 5 pages long. The email from Attorney Tim is about 2 pages long, and I'm going to bring that up. And while I'm bringing it up, Robert, what's your comment?
Well, I'm simply going to say that in the body of his email, he talks about how extortion and coercive tactics are something to be looked down upon. And
Now, wait a minute. Whoa. You're not going to accuse him of attempting to extort me, right?
No, but I
I'm not
think
gonna allow you to do
coercion,
it.
definitely. He threatens you with potential litigation at the end.
No.
right?
He didn't threaten me.
Yes, he did.
He said that if I have someone on the show that is going to continue
He said,
to
you know it's
proffer-
false, so if you repeat it, it's repeating the defamation, and everyone can be held liable who knowingly
Well,
repeats the slander.
I don't know what is and what is not
of course
false
not.
in that email.
Of course not. That's why I'm saying it's clearly ridiculous.
What I
but
know
he's
is
using coercion to
what
try
I
to
know
force you
is
to be
100%
silent.
true, black and white, no gray, is what I reported in my story, or pardon me, the story by Ted Durden and myself, because I verify my facts. I have never given fake news on this show, and I have never lied to anybody. So the only thing that I know is 100% true. It's what's in the story by Ted and myself. I now want to go to the responsive email from Attorney Tim. Mr. Appel, I understand that Mr. Cap has sent you a long-winded email. I wish to respond. You will find that I am not as verbose as Mr. Cap, perhaps because I am not trying to distract. Mr. Cap tries to obfuscate the, I think, did I pronounce
Obfuscate.
Obfuscate, thank you. The only key facts applicable to Dr. Fishman's suspension. 1, Dr. Fishman was convicted of a felony. 2, Dr. Fishman admitted that the felony was related to the practice of medicine. See attachments to this email, which are the complaint filed by the Michigan Board of Medicine alleging that the felony conviction related to the practice of medicine, and the stipulation from says Dr. Cap, he meant Mr. Cap, agreeing that the allegations of facts and law in the complaint are true.
I think he meant Dr. Fishman.
Yeah, I think so.
Yes.
Mr. Cap, thank you, Ted. Mr. Cap claims that Dr. Fishman is entirely rehabilitated and he has a supposedly unblemished record and should not be suspended. However, says Mr. Cap. I think Mr. Cap purposefully ignores unblemished record and should not be suspended. Mr. Cap purposely ignores that Dr. Fishman lied on his applications to the DWC in 2003, 2005, 2007, 2009, 2011, and 2013. I previously provided you with these applications in which Dr. Fishman falsely states, under penalty of perjury, that he has never been convicted of a misdemeanor or felony related to the practice of medicine. Those are recent acts and are not the acts of a rehabilitated man. It is no justification that Dr. Fishman lied because he knew he would not be appointed to a QME otherwise. Indeed, that makes it even more damning because his obvious intent was to mislead to serve his own economic ends. As an aside, I was surprised that in your brief written article on this matter, you stated that Dr. Fishman was successfully reappointed in the above years, but did not mention that such reappointment was based upon his written lies. Again, I'm reading an email from Attorney Tim. I do not verify whether or not something in the email is correct or not. I'm just reading it word for word, because I fully believe in the fairness doctrine, which Ronald Reagan disposed of in 1995. We've spoken about that, but I still practice the fairness doctrine. Mike, if you could be so kind and pick up the remainder of this email, starting with those are not.
Those are not mere technical difficulties. The California workers' compensation system depends upon the integrity of its participants, particularly the doctors who serve as QMEs and AMEs and who are supposed to be above reproach. A felon who continues to lie under penalty of perjury does not meet these qualifications. Mr. Cap tries to distract from the basic facts above by throwing as much shade as he can upon me and Mr. Nazimi. It reminds me of an old adage learned by lawyers. When the law is on your side, pound the law. When the facts are on your side, pound the facts. When neither are on your side, pound the table.
I think I've heard that somewhere before. Please continue.
Mr. Cap's emails amounted to a lot of table pounding. I am happy to go into detail as to how and why Mr. Cap's allegations against Mr. Nazemi and me are patently false if you so desire, but will not do so here because his allegations are irrelevant and meant only to bully and distract you from the only relevant facts, which are those set forth above.
Does he give a name, an address, a phone number, contact him,
Well,
or
there's
no?
There's one more paragraph.
Oh, please go. Please continue.
Mr. Cap's insults and bullying statement are obviously intended to convince you to not publish the truth about Dr. Fishman. I note that besides Mr. Nazemi and me, even you were not beyond Mr. Cap's insults when he made such offensive statements as, "Your webcast had a seemingly microscopic footprint, but seemed to have about 100 listeners per episode." This gives you an idea of the type of man we are dealing with. Regards, Ronald Tim, Esquire, the Tim firm, TYM.
And once again, we have just finished reading both emails word for word. One by Howard Cap, representing the doctor. One by Ronald Tim, representing whoever else.
Nazemi.
Thank you. I do not say whether or not the emails are exactly correct, somewhat correct, a little bit correct, but we read them on here for full disclosure, word for word. Friends, Scott, what's our time? How much we got left? What? We're at 1 hour exactly? I'm going to take the next couple of minutes. We've got over 100 shows in the tank. Each show is about an hour long. Anybody that wants to check my credibility or know where I'm coming from, I consider myself an open book. Born and raised in Southern California, went to school in Southern California, worked in Southern California for over 45 years in all sorts of jobs. Been in workers' compensation for 28 years. I've assembled this fantastic crew, which has over collectively 100 years of experience in workers' compensation. Yeah, you're damn right, Mr. Cap. I ain't no attorney, but I have my credibility, and I can look at myself in the mirror when I go to sleep and wake up, and I'm satisfied with what I've got. I've never, ever lied or purposely misrepresented the truth in my professional career. You know, maybe if I've had a few too many shots and I'm at a bar trying to impress some chick, get her in bed, then I could see myself, distorting the truth. But in all seriousness, from a professional point of view...
Now, you would have went pro if you didn't hurt yourself in that big game. Everyone knows that, okay? If you didn't hurt your knee in the big game, everyone knows you would have went pro. Okay?
And by the way, speaking of the big game, I guess the one news story that I will read, the one news story is that the Super Bowl is this weekend, okay? Patriots against the Rams. Patriots are favored by 2.5. I am
by
picking...
a field goal, huh?
Yeah, 2.5. I am picking the Patriots to win 30-20, and I will tell you the keys of the game. The Rams, if they have more than one turnover, they will lose. The Patriots need to have a combination of 150 yards rushing and 150 yards receiving from their backfield. If the Patriots do that, they will win. But I think the key is the Ram turnovers due to their inexperience.
I'm going to say 37-17 Rams, and it's going to be 14-3 Rams at the end of the first quarter.
Ted, you want to take it?
Ted?
You got a prediction for the game?
Ted wasn't even listening to us.
I'll go first. I'll let Ted think about it, all right? I'm going to take a bold prediction.
37-17 Rams over the Patriots.
All right, I'm going to take a bold prediction. I say Rams roll the Patriots 45-10. I think Aaron Donald and Ndamukong Suh up front, too much pressure up the middle, stop the run game, getting pressure right in Brady's face.
They got
to
be
a long
Brady.
day. It's going to be a long day for that pretty boy Tom Brady, okay?
And I guess I'm going to be the one that disagrees. And trust me, I'm not a Patriots fan. I can't stand them. I hate them, period. But with what they bring to the field with their experience, and especially with Tom Brady, unless somebody shoots him in the head, breaks an arm, breaks a leg, He's proven to be pretty much unstoppable. Unfortunately, I'm going to predict that the Patriots are going to beat the Rams 28-21.
That's pretty close to what I said, 30-20.
Big will be if Gurley is healthy. He hurt himself there late in the season, and in the playoffs he hasn't looked right. Rams have still been winning.
They haven't been playing him because they have Anderson.
Well, Anderson's been playing great, but Gurley just didn't look right when he was playing. He didn't have that same form that he, set the league on fire with during the regular season.
I think Gurley's game free.
I think so. See, the only thing that I hope
wrap it up.
I just hope that the Rams just don't make silly mistakes like the Kansas City Chiefs did, number 55, lining up offside with a minute 45 to go in the game. I mean, somebody of his experience, I had a problem with that. Plus, why didn't the ref call that before the play?
Well, if you line up in a neutral zone, you're allowed to snap the ball. It's going to be a free play for the offense.
Yeah, but if you can get because you could get back before snap time.
Yeah,
so
but
he's not going to call it.
Exactly, but he was lined up and he stayed in a neutral zone by the time of the snap. So it's a free play. Yeah. Usually you have the coach there on the sideline yelling at you. I mean, in high school football we have that. Trust me, I line up offsides a lot. I barely knew where I was going half the time.
Sorry, guys, I could talk about Super Bowl for a whole other show, but we got to go.
Bad for the Saints.
Yeah, my name is Steve Appel, and we're brought to you by A1 Law, Santa Monica Tickets, and of course WorkCompCentral.com. For the Chief of Staff, my right-hand man, Dr. Michael Zyma. For the best-dressed man in workers' compensation, Ted Durden. For my protege, attorney Robert Ozeron. Scott Walton of Uncle Studios on the board. Retired attorney back in Munich, Germany, John Scalia. And all the good people back at WorkComp Central that continue to support and improve this project, including Christine Chavez. My friends, this is the reason why we do the show. My name is Steve Appel. We'll see you again next week for another edition of WorkCom Matters.